With agenda item number 4, discussion of Texas Education Code Chapter 12, Subchapter B, Home Rule School District Charter. Trustees, in front of you, you have copies of the statute front and back. I will say that this is nothing that this current board or past boards, I believe, have ever dealt with before. We're in a unique situation, and we're just here to ask our attorneys questions about the statute and seek advice on how to proceed. We may or may not go back into closed session, but we'll open it up for questions. I'm going to start with Trustee Mitchgay.
Okay, I emailed a set of questions to you, and I'm just going to go through those.
That's okay.
My reading of the statute, the board, with a 2/3 vote or more, can...
Point of order.
Yeah.
I was just wondering if, since the attorneys are here, and there are perhaps constituents who are listening to this, they don't have the statute in front of them.
That's true.
I was hoping that the attorneys would give us an overview of exactly what is here before we ask questions about it, and that would have that on the record so that we would know, and anyone listening or paying attention or interested in this would also know, rather than our asking questions out of the blue. And I would think that would be the appropriate order.
And also some background about how the statute came to be and what its main purpose was at the time of origination, because I've had some interesting conversations about that.
My trustees make good points, and you might actually answer our questions before we get to them. So who wants to start?
I can do the
Thank you.
background. This chapter was part of recodification of the Education Code in 1995, and it is included in the same chapter as the provisions for open enrollment charter schools and campus charters. It was part of a move back then to provide what they called school choice. They're still talking about school choice, alternative forms of governance and programs and other things for people to use. As I said, it was adopted in 1995. This particular thing, it was modeled after home rule charters that are used for cities in the state. The city of Dallas has a home rule charter. They're basically the constitution that establishes how the city is run, how it is governed. As of today, no one has taken advantage of the home rule charter part of this. There's speculation as to why. I was working at the Capitol after it was adopted, and initially it seemed like nobody wanted to be the first, and then I think at some point people sort of forgot it was there. It has a pretty steep requirement, which we'll go into at a later time. When the public votes to approve this or not approve it, the total participation has to be 25% of the registered voters, and you all are very familiar with school board elections, and generally we're lucky to get 10%. So I think that was maybe another thing that held people back. Do you want me to hit some of the highlights, or okay?
If you feel it's important for us to know.
Well, generally the provision, the home rule charter exempts, or doesn't actually exempt, it just allows a district to operate under its own rules and not under many of the rules that school districts operate under normally.
Name a rule, like, for example.
Well, there's a laundry list of rules that do apply. Like as an example, I'd say one of the ones that doesn't really apply is Chapter 21. Sets up the provisions for hiring and termination of teachers and all the due process requirements. The only provisions of that apply relate to the provisions that say you can't require or coerce teachers to join groups. You have the right to join or not to join, and if you do join, you can have your dues subtracted from your paycheck. Other than that, all of the Chapter 21 provisions would not apply unless the people writing the charter wrote that in and the voters approved it. So that's one example right there. They would still be subject to all the rules as far as you can't discriminate, criminal laws, public education information management, student admission, student attendance, 22 to 1, no pass, no play, Chapter 39, which are the accountability provisions, so they would still be subject to the STAR exam, and there's a number of others that I'm not hitting on right here. You've all read the paper, and the paper did a good job of setting out what needs to happen for this charter to occur, and that's either 2/3 of you, 6 of you would vote to appoint or adopt a resolution ordering that a charter commission be appointed, or you are presented with a petition signed by 5% of the registered voters. If either of those occurred within 30 days, you would be required, you as a board, would be required to appoint the commission. That's 15 people, must be reflective of the racial, ethnic, and socioeconomic diversity of the district. At least 8 must be parents of school-age children, and 4 must be classroom teachers, which would be selected by the professional staff of the district AC. The content of the charter would describe the governing structure of the district and acceptable student performance, compliance with other applicable statutes, etc. There's a provision here in the law that says it would be subject to pre-clearance, but it no longer applies because of the Supreme Court decision last year, Shelby County versus Holder. Pre-clearance basically doesn't exist anymore. The Charter Commission submits the proposed charter to the Commissioner of Education. The Commissioner has 30 days to review it and can either approve it or be silent, in which case it would be deemed to be approved. The proposed charter would then be submitted to the voters. The board would call the election at the first uniform election date that occurs at least 45 days after the date. And as I said earlier, you need at least 25% of the registered voters to participate. That's both sides for that election to be valid. If it doesn't work the first time, you order another one. You can keep ordering them, but the only one that I see you're required to do as far as try again is the second election. There are provisions in here for charter amendments, which are very similar to the provisions for the approval in the first place. The governing body of the district, once the charter is established, could on its own motion submit a proposed charter amendment that goes to the commissioner and then goes to the voters. Or there's also the same type of provision, 5% of the registered voters can submit a petition asking for an amendment. I think I've hit most of the highlights. There's some other things in here like you can create the district can adopt and operate under any governing structure. This board would continue to operate until such time as the other board became effective, which that date would be included in the charter itself. And anything else? That's pretty much it in a nutshell.
The period of time, if, for example, 5% ratify or 5% of the voters come forward with a petition, or there is a petition representing 5% of the voters, I should say it differently, at that moment, what is the process that this board undertakes, since there are no guidelines established, there isn't a precedent, there has never been this type of process before? How does that get created? And then it's my understanding from the statute that then that when the commission is ultimately appointed, seated, and doing its work, it has a year to come up with a plan.
A maximum of a year.
Maximum of a year, right.
30 days once you've received the petition to appoint the board, appoint the Charter Commission.
We also have to establish, if I'm not mistaken, the charter itself for the commission.
So the Charter
Commission.
Don't we give it a charge?
No.
The Charter Commission will draft the charter.
Does this body give that commission a charge?
Sure. Well, you can say we're appointing you to do what the law requires you to do.
The board appoints the commission, and then the commission creates the charter.
They can decide the scope, the entirety of what it is they're
Absolutely.
going to look at.
Once you appoint the commission, your job is done.
It's out of our hands.
Yes, ma'am.
After that, out of the board's hands.
Yes, ma'am.
Us in that, out of the board's hands. Yes.
You're mainly you have some ministerial duties after you appoint the commission, but nothing really substantive.
Okay.
Do you have any, you're done? Okay.
That was overview of the gist of it.
Anything to add?
And the 15 members that get appointed are bound by the same rules of public service. In other words, the entire commission process would be subject to the Open Meetings Act. It would be subject to individuals who would have to make full disclosures. They would also be, I assume, under the some provision to deal with their conflicts and with related
It's the governing body.
background checks or
Yes.
some other process by which, they would be vetted or otherwise.
It's the governing body, so they're held to the same standards.
They're public officials,
That's
essentially. Okay.
Okay, just want to make sure that we all understand that if a petition is presented to us with the requisite number of valid signatures, the board has to appoint a charter commission. We have no ability to vote yes or no whether or not we want to proceed.
That's correct, it's mandatory.
Okay. And then if they, with respect to the questions that were asked about charging the commission, the board cannot instruct the commission in any way to say, write a charter that keeps all the rules the same except changes the length of the school year. We have no ability to do that.
No.
You can suggest it. I don't think you have the authority to make it get into the charter.
Okay, and then when the charter commission prepares a draft of the charter, does it go back to the board for any comments, or does it go directly to the voters?
No, it goes directly to the commissioner or education for review and approval.
But in terms of the board's ability to make suggestions or changes to the charter?
Directly to the commission, not to the board.
Okay, and then if the charter is approved by the public, and Jack, I think you touched on this, and the board wants to change something in the charter, what is the process? The board can, by a 2/3 majority vote, order another commission to be impaneled, and then basically has to hope that the next commission might make the changes the board recommends.
Once you appoint a commission, they are the governing body. The board has no ability to then vote on anything.
Well, let me clarify that. They're the governing body with respect to the charter. In the meantime, while the charter committee is working on the draft, the elected trustees will still be governing the district.
Sure.
That's correct.
Absolutely.
It's only when the charter, if the charter passes the requisite vote, is when you would no longer be the actual governing body.
Okay, and then with respect to the choices that the charter commission can make, and it can, I think you mentioned that much of Chapter 21 is something that the charter commission can decide whether or not to include in the new charter. What about the accountability and high stakes testing rules and STAR testing?
They're all something that the district would still be under.
Okay, the charter commission cannot change or make the district not subject to the high stakes testing. Okay, with respect to issues like breaking up the district, which we sometimes hear a lot about, certainly we do in the White Rock area, does the commission have the power to break the district up into separate parts, assuming the voters approve it?
I'm not absolutely sure. The very first section in the law says the adoption of a home rule school district charter by a school district does not affect the district's boundaries, which would seem to me to say that they can't by charter change the boundaries, or I think you could argue that the answer is no, but this has never been done before.
And if we wanted to get an opinion on that from, is TEA the place we would go for that opinion, or would we?
I think we could research that information for the board and provide.
Well, I guess I should clarify that I understand what you just told me. It's not the board that is going to be making any of those determinations. If the commission decides that that's something that they want to explore, that is something for the commission to look at.
Sir, and the commissioner will review that for legality and the commissioner's opinion about whether that would be valid or not.
Okay.
This board could still ask for an opinion.
This board can still ask for an opinion. That's what Dr. Blackburn asked.
I'd be happy to send a note to the general counsel at TEA. My experience with them is generally they're hesitant to answer questions like that.
And then backing up to the situation where a petition with a valid number of signatures is presented to the board appoints the commission. At that point in time, the board has nothing left to do with respect to taking action on the charter or the charter commission. The charter commission's impaneled, and they draft a charter and bring it to the voters for a vote. The board doesn't.
You're missing a step. It first has to go to the commissioner
Right.
for approval.
The board does have to call for the election for the approval, but I think it's probably a ministerial duty. That means basically if you get the commissioner approves it and it comes to you, back to you guys, you have to approve or call for the election.
Okay, and the board is, and this is a question, is the board able to pass or consider a resolution supporting or opposing whatever charter might be drafted?
Sure. I don't see why you couldn't.
And individual trustees, are they permitted to take positions in public one way or the other with respect to the to a charter if the commission drafted one, or with respect to the petition? Can individual members of the board advocate that people should sign the petition, and then if there's a charter, can individual board members advocate that voters should vote for or against the charter?
I've not seen anything that would prevent an individual board member in their individual capacity to support or not support the proposed charter. But we can dig in and find if there's any research or analogous research that would touch on that. But I haven't seen anything after reviewing this that would prevent that. Does anybody else have anything different?
Trustee Blackburn said that board members can't use district funds to advocate.
Oh, no.
Yes, we understand that. Okay, that's all I have, Mr. President.
Trustee Solis.
Mr. President. Let me start first. You talk about this 15-person committee, and you mentioned it has to represent or be representative of the racial breakdown of the district or the city.
Of the district.
And when you say the racial, you're talking about the student population.
Just says the racial, ethnic, socioeconomic, and geographic diversity of the district.
Those who are wondering specifically about this, it's section 12.015.
Section B.
Is it the voters of the district?
Section B.
Or the population of the district?
It says the district.
The district. The geographic diversity of the district.
Strikes me we might need an opinion on that.
Yeah, so I'd like if we can get an opinion on that, that'd be helpful. Because I'd be interested in, I mean, we got nearly 72% Hispanic student population, our low income.
That's our student population.
Popu-
There's a difference
my-
between
my-
total population.
So, if we can get an opinion, that'd be very helpful. The governing structure. Who picks this 15-person committee?
The Board of Trustees.
So, does that mean that I get to pick 2 each trustee, or do we have to come to an agreement as to who these individuals are? I mean, we have to vote on it, obviously, but
The statute does not spell that out. It just says that the board has to pick 15 individuals that's representative of the demographics in the district. The majority of the members have to be parents of school-aged children, and 25% have to be classroom teachers.
The board
So-
can, I'm sorry, the board can only act as a body, so maybe you could suggest somebody, but the appointments would have to be approved by the entire board. Sorry.
okay. And repeat for me the 15 slots. A majority have to be
Majority of the members have to be parents of school-aged children in the school district,
school district.
and at least 25% must be classroom teachers selected by representative of professional staff.
Okay. So at least 8, sorry. Math is, I'm working on my math. 8 have to be parents.
Yes.
Okay, I can do the rest. All right. What are the boundaries as far as dialogue is concerned between trustees and the committee members? So I've heard talk of, Trustee Mishke brought up, I think general boundaries, but when can we absolutely not talk to these people on the committee? From the very beginning, or can I talk to them as an individual citizen throughout this process, or?
I think it's sort of like what Ben said earlier. I don't know of anything that would prevent you talking as an individual. When it is subject to an election, there will be some prohibitions about using district equipment or using your position, but this is very much a gray area.
Okay. The governing structure. You brought up the potential for a shift in the governing structure, and it's really, I mean, I'm getting the sense that this is really carte blanche. You can just kind of do whatever you want to do if you're on this committee, and if you wanted to get rid of the school board, you could get rid of the school board. If you want to keep the school board in place, if you wanted to extend the term of school board members, if you wanted to make school board people who want to run for school board go get petitions signed, if we want to pay school board members, all of these things are in consideration for this committee, if they so choose.
Section 12.025 says a home school district may adopt and operate under any governing structure.
So I get the governing structure. Let's change the conversation really quickly, if we can, to the management structure. Does this open us up to say we don't want to have a superintendent, or we would rather the district run just by an appointed board, or are there any limits on that?
No, they can do that.
Sorry, what did you say?
Yes, they can do that.
All right.
Oh,
I should have a handout that has some of the laws that you still have, the governing body still has to follow, and the ones that you don't have to.
So,
Dr. Blackburn had a clarification to the conversation you had about whether or not the board can be involved in the management of the district under a charter, and he said all this, of course, has to be approved by the TEA commissioner, and with the implication that that's probably something that the commissioner would not approve.
agreed. All right. Those are the questions that I have. Thank you.
Can you, hi, can you explain, I know the law passed, I don't know which bill, about charters and the board have the right and the option to open charters? Is it, which law is it, Senate?
SB2.
bill.
No, SB2 and,
SB2.
and also HB5 giving us
5.
other
So could you
provisions.
clarify the difference between home rule charter and that? It's the same? Dr. Blackburn said it's the same.
You're talking the
I don't know.
subchapter D. You're talking a subchapter D.
SB2 modified Section 12, but not this portion of Section 12.
Can you explain the difference? Because I know the law, it changed in 2013 that they gave us the right to do all of this. We,
They gave you all the right to grant open enrollment charter schools, I believe. Is that correct?
in district charter schools.
District charter. So this is different in that open enrollment charter schools are charter schools that, like Dallas can, that are approved by the State Board of Education. They're free of some of the laws as well. This is a home. It's called a charter, but it's a home rule charter. The charter is the governing document that establishes how this district would operate.
Can we get an opinion on the difference between the law that they gave us
Sure.
the right to be able to do charters versus the home rule? Can we get an opinion of that? And then can you clarify, understanding the commission, the single member district, how does it work that in I think it was 73, maybe we went to single member district because of equal representation at the board, of the history of DISD. How is all that impacted with home rule charter?
It could be impacted. That, as we said earlier, there's no pre-clearance anymore, so we won't be going to the Justice Department to have them tell us it's okay beforehand. If there are issues with that after the fact, they would have to be handled at that time.
Hypothetical situation, well, follow up. If you get all your signatures from a particular subgroup and you get not that many signatures from another subgroup, how does that work? Does that go to the Justice Department? So you can get all your signatures from, for example, North Dallas,
It
and
says 5% of the
very
registered voters.
very few signatures from the southern sector of Dallas. That doesn't have to go to, they don't look at. So this home rule charter, if I understand it, so you can get all your signatures from one subgroup and don't have to have any signatures from another subgroup, or maybe majority of the 5%, you get 4% from one and 1% from other. So it's not the signatures don't have to represent the makeup of the district.
Just 5%.
5%
Of
of
registered
registered.
voters. Registered voters.
So the single member district in 1972 or 73 that people fought to have representation at the table, we technically can go back to that. Although the commission is appointed by the board, the commission is only for a year, correct? And then it's voided.
Right.
So how does that look? It's for a year, and then it says right here, then after a year, well, after a year if they don't.
But then you're not submitted within a year's sunset. They no longer can act. If it's not done within 1 year, submit the draft to the commissioner for approval.
So once they submit the draft to the commissioner for approval, 15 members represent of the district, as Trustee Miguel, they have a year to submit it. The commissioner accepts that submission, and that is become the future of the district. Election of the commission accepting the,
The voters of the school district would then have to vote as to whether to adopt the charter as the governing document or not.
so would the commission control the charter, or they set that up as if they want a board, they can set the board up to say, we want the board to look a third, or we want the board to be all men, or we want the board to be all women. The home rule charter, what they write in the charter, that's what is written and become the future of the district.
I doubt if the commissioner would approve it if they said they have to be all men, but
I'm just saying, I mean, they write what the makeup looks like. And then the commission accepts that makeup.
the commissioner will review it as to the legal.
What are you, excuse me, Trustee Matt, you're talking under your breath. What did you say? You said something.
Saying I'd have a hard time approving a commission that required all the board members to be men.
That was a hypothetical situation.
Be on it. That's all I said.
I'm just trying to understand. The commissioner then it goes to the commission. The commission accepts, the commissioner accepts the commission's report, what they say the charter should be.
He or she would review it
And approve it.
and approve it.
Or request modifications.
Yeah.
And then it goes to,
Voters.
and so once the voters adopt, do the voters have an option to say, we want, we want something added back in the charter?
It's up or down.
It's up or down. So whatever the commission, do the commissioners have to listen, do the commissioners that are appointed have to listen to the voters?
They're a governmental body. It doesn't say what they do, whether they hold hearings, whether they hold public meetings. It's going to be up to them.
So it's up to these 15 people to determine what the district will look like in the future. And so they don't have to abide by public meetings, community meetings.
If they hold a meeting, it has to be a public meeting posted. In
I know, just to hear the ideas, to say from the parents, they don't have to, the commission, the 15 people, they don't have to listen to the public.
Well, they're going to have to vote at some point to approve the commission.
It would be smart to go. But they don't have to go out to the parents of the different feeder patterns and say, what do you want to see the future to be? They're not required by this charter to do that.
It's silent on that.
It's silent. So they can, 15 people can meet, determine what they decide the charter to be, submit it to the commissioner. The commissioner says yay or nay, then put it on the ballot, and the voters say yay or nay. So if they, whatever they want the charter to be, the 15 people will determine that. And then what happens to the board of trustees? So the single member district is no longer a single member district because the charter will determine.
That's correct.
I didn't hear you.
That's correct.
So this commission will replace single member district. Could replace single member district, and that was false. Okay. The other, can you get us in writing the roles and responsibilities from a legal opinion of trustees in this matter, so we can know? So I don't want to cross the line. So we can understand that gray area, Attorney Elrod. I would like to see that in writing. And then that's for now.
Got a follow-up question on the preclearance. Can you just expand on that just a little bit more? I don't want to get off topic, but I think it's on preclearance and how this thing could move forward.
Well, there is
in the
no more
courts.
there is no more pre-clearance. Pre-clearance was part of the Voting Rights Act, which was set up so that any changes that had to do with voting, you could change a precinct line, had to be submitted to the Justice Department for pre-clearance to see if it impacted the rights of different members of the public to vote. And the Supreme Court last year decided that that didn't apply anymore.
So we could go through redistricting next year.
Don't have to get pre-clearance.
Different, but we don't have to get pre-clearance. Correct. Okay.
This is a question from Dr. Blackburn regarding the petition signatures. Is there a process to verify the validity of the signatures on the petition?
The statute does not make reference to that, but probably the Department of Election would have to verify the validity to make sure they are registered voters within the district. They will be responsible for that.
I think that
Can I go back to your,
Just looking for
can I go back
hands.
to your pre-clearance
Sure.
question? Since I don't want to take up my time on this, but I do think we need clarification on this. So this district was part of a lawsuit once upon a time to take it away from a certain structure and put it into single member form. And that was to do something specific, that is to balance interests across 380 square miles and a very large footprint. When this home rule school district charter was created, wasn't this really for the little districts out there, the rural counties and other entities that didn't have a whole lot of options and resources at their disposal? Wasn't that the origination of this
I can't.
subchapter B law? I think it would be good to know, because the large districts, I mean, we're this question about population that Trustee Solis brought up is an important one, because there's a distinction between our school population and the population of the residents, or however you want to define it, of those who live within this 380 square mile jurisdiction. And the second thing I would question, or at least want to see some understanding around, is we cross over 16 or 17, I don't know how you count it, municipal jurisdictions, and we don't necessarily cross over them in their entirety. For example, we don't cross over 100% of the city of Dallas. We cross over nearly 100% of the city of Addison. So these are voters that cut across a larger set of municipalities than looking at one or being able to just focus on one, where we're evenly aligned. So the issue on voting rights is not just around the representation of your racial and other considerations, your civil rights considerations, but it's also around your voting populations and your tax base. And so I'm also interested how that comes into play here when we talk about representation. I have other questions, but I just didn't want to get off you around that topic. Why don't you go, Trustee
That's
Ranger?
okay, go on.
No, please.
I'm thinking of a couple
You're
of things.
thinking.
Sorry.
Oh, I was gonna. I guess I'm going back to the pre-clearance in the lawsuit and what brought us to a third. And I understand. I know about the voting rights with the Justice Department, the pre-clearance. So this absolutely will not have to go through any pre-clearance.
Correct.
And it's just so ironic. We're bringing this year because there was a point in history in Dallas that there was lack of representation from the African American community and the Latino community. So that's how we got the single member district, so we can have equal representation. So this whole home rule charter will kind of take that we're bringing the conversation about race to Dallas in November. Been having dinner tops about it. It just seems to me, when I looked at the signatures on it, there was one Latino representation on that committee, 2 African Americans, and 2 Anglos, and the district's majority Latino. So I'm just trying to figure out, are we going backwards? And as Dr. Blackburn mentioned, I would love to know the concerns of what is the end, what are they trying to accomplish with this home rule charter? What exactly are they trying to accomplish? Because it is something that they don't like the trustees, and they want a whole new governing body. They can't get what they want. I mean, normally when you have groups that try to break off, as with some of our parties, and you know that other party, it's because they're disgruntled with something. So is it possible that the group can present to explain to us what part of, when I look at the exemptions that they are under versus the policies that the state, because some of the policies are local policies, and when you talk about local policies, that's policies that the board control. Some of the policies are state policies, like the testing. The testing, House Bill 5 is state, but however, ACP is local. So is there something that you could sit at the table to discuss? What is it that you want to see? And we have a voice of discussing, why are we going to home rule charter? Why did you go this route? What is it that you want to accomplish? Is it White Rock ISD? Is it South Dallas ISD? Is it North Dallas ISD? What is our end goal here? And what is it for children, and what does it mean for our children with academic achievement? So I'm really confused on, and we're in the middle of talking about, we need to talk about our budget, and so this is I'm just trying to understand. So can they present? Is that a line? Is that a role and responsibility that they can present to the Board of Trustees to help us have a better understanding of what is your outcome of this?
The board can invite those individuals to present to the board what their intent is and what their goal is.
Okay,
So
because
there's
I
a
didn't
better understanding.
Yeah, I would love to know what is the end goal here? Because in that letter that was presented to the board, it stated stated a lot of things. You know, it talked about flexibility in the hiring and the flexibility, I think, in teacher select. I mean, it talked about a lot of things that I'm trying to figure out. What is your end goal here, and how is it going to benefit our children? And why are you going this route? And what is the end goal? I would love that, President Cowan, to understand that if they can give it in writing. Our goals are 1, 2, 3, and then how it's going to benefit our children. Be curious to know how many of them have children in the district as well, too.
People are, may I just ask one question while y'all are thinking about it? What does this law specifically allow the school district to do that we can't do now? And that might be a question for the attorneys or the superintendent. Well, let me clarify. If the process goes forward, if the commission forms a charter, if it goes to the voters whenever, and it is approved by the voters, and what is the difference between what the school district can do versus what it can't do now?
The major one, I think, major issue that it can't do now if it were to pass is the Chapter 21 law. That obviously the governing body would not have to follow most of Chapter 1. If you wanted to terminate an employee, you wouldn't have to go to TEA and get a hearing, have the rules of evidence apply, the rules of civil procedure apply, pay for the hearing examiner, pay for the court reporter. Those type of things should be more in line with how most private businesses have employment. So that, to me, that's the major issue of what could change. It doesn't have to change. The commission you appoint doesn't have to do that, but they have the ability to not be under a lot of Chapter 21. And there's other ones in there, but I think that's a big issue.
Big one. You're not going to be subject to the minimum salary schedule. You could establish your own salary schedule. Governance, of course. You could have your own school.
Okay. But we also could, we being the charter itself, could recommend that you keep Chapter 21.
Certainly.
You keep the school year the same.
Certainly.
Okay, so it's
They just have the flexibility, to not.
They have the ability to. Okay. Okay. Did you? Sorry to interrupt. Did you want to add?
I could if you. I'd have to get a legal opinion about some of these, but for example, there are 187 days that we have for teachers. We could possibly change that. That's a requirement by law, if I'm not mistaken. We can waive up to 5 professional development days, get a waiver for professional development days. It would be good to have more flexibility. That would be something that a charter commission could do. The school start time, which is now, I think, the 4th Monday in August, a commission could change that, I guess. And there's also just several personnel rules. For example, non-Chapter 21 evaluations of administrators at central office are open to the public right now. That could be changed. There's also some categorical funding requirements for different different types of programs and codes, line codes that we have to follow. We could get flexibility for that. There's also several different mandatory trainings, and there's a list of it, almost a dozen mandatory trainings for teachers that could be changed. And those are just off the top of my head, some of the things that a charter commission could change if they were so willing.
Well, I just want to first of all, before getting to a question, just to restate for clarity what I've heard and what I understand that you're saying and what I read in the code. This is the Education Code, Chapter 12, Title 2, Public Education, and then Subtitle C, Local Organization and Governance. But it's Chapter 12, Charters. And so this has to do with charters and charter schools, correct? So actually, this is what this whole thing is about, charter schools, and could potentially, I mean, this whole section of the Education Code. And then the actual area with which we're dealing is Subchapter B, Home Rule School District Charter. Is that correct?
Yes.
So, okay, just want to be clear that this is a certain part of the Education Code that deals with charters that some places, not in Texas, perhaps have used to go the way of making their district a charter school district.
That's correct.
And then this law, again, came into effect in 1995. But if this group pursues it, Dallas would be the first school district in Texas, throughout Texas, with more than 1,000 school districts. Correct?
That's correct.
With more than 1,000 school districts, large, small, medium, to try this. This is the first time. 19 years or so that this has been in effect. Also, this law, should this be pursued, would remove the public's right, could remove the public's right to elect representatives to the school board.
Correct.
The public would have nothing to do with this public institution should the charter be written that way. According to that commission, the public may not or could not, would not necessarily elect its own representatives, each district to represent them. Correct. Ms. Barlow?
Yeah, you wouldn't be, the governing body wouldn't be required to do that. They could do it, they just wouldn't be required to do that.
It depends on what that charter says, right? Should that commission submit that charter and
Correct. The voters approve it.
and the voters approve that. All right. And as the law was written, as I read through it, it does require a high level of community participation. A high level of community participation. And when you read through the, the appointment of charter commissions, the very first one is the Board of Trustees shall appoint a charter commission if the board receives a petition requesting the appointment of a charter commission to frame a home rule school district charter signed by at least 5% of the registered voters. That's the first. And then, of course, it could be, you could go to the second, but that was the first one mentioned in the law. The letter that we received, and by the way, on the board document, I didn't check just before I came here, but on the board document, the Texas Education Code Chapter 2 is posted, correct? On the posting for the meeting, I should say.
Well, we can discuss.
Is that? No. It is not.
Chapter 2.
Discussion of Texas Education Code Chapter 12. That is posted on the on Sire. That is posted on Sire. Is the letter that the board received that I assume prompted this, along with other things that we've read about and heard about, meetings before, all the discussions before, but is that letter posted on Sire? It would seem that that would be President Cowan, and as much as this relates to that, this is the reason for this meeting, I suppose, so requesting that that letter from the group be posted there as well. This letter, the letter that we received, is about action that a group is taking. And to me, it appears to be a radical assault on the district, and the district's being a public institution. So all that I've read here in the education code, this education, part of the education code, Title II, Chapter 12, Subchapter A, and Subchapter B, having to do with charters and homeroom district charters, all of that seems to go against everything this district has built and developed as a public school district. But the group is moving ahead with what it wants to do. So I suppose our purpose here today is simply to discuss this because the group has said that it is doing what it wants to do in this regard, and started that process before. Is that correct? That we're discussing it because this
Yes.
thing. All right.
Superintendent Miles has something. Are you in support of this, Superintendent Miles?
Know enough about what they want. I think it's a board decision, and we should follow the legal processes.
Thank you, Mr. President. Is there any type of guidance regarding how something like this should be framed to voters in the first place? I mean, you create somebody's out there, in this case, a 501c4, which is a political organization, has been formed to go out and is raising money to get petitions signed. Is there any guidance about the language there and what that does to trigger a commission, and whether there's any rules about, what that language is supposed to say or not say, and how that campaign, if you will, for getting those signatures is to be carried out?
The law, once a governing body has drafted a charter, the law says that it's posted on the ballot as whether...
Oh, no, I'm not talking about that stage. That's
Okay,
way down the line.
okay.
I'm talking where we are today. So why we're sitting here today is a 501c4 has initiated a process to go out and get voter signatures to be able to bring this issue to this body to cause us to have to form a commission. Is that right? But a 501c4 is not the same thing as, for example, what we would have in a traditional bond election or some other process where there's complete transparency about the nature of the organization, that it's apolitical, that it's there really to try to open up the possibilities of a process. Can you speak for a minute about that? Because I recognize that there's nothing in the guidelines here, but at the same time, that strikes me as being a very non-transparent way to force an issue. And to voters who sign that petition, what are they being told, or what's the responsibility of that body to educate the voters appropriately with factual or other information that voters are then signing their name on a petition?
50C14's responsibilities would be governed by that statute. As far as involvement between board members and the 501c4, I haven't seen anything that prevents that, like certain laws when you're under a bond election or similar circumstance. So we can look into that for you, and I think that was one thing you wanted us to look into.
So, a lot of what we're hearing here is an outright criticism, it sounds like, of what Austin hasn't been doing, the things that a home rule district initiative would be able to grant a school district is flexibility around areas where the law today is rigid for our sake. Is that all we're talking about here? I've heard things like Chapter 21, I've heard things like the hours in a day, things like this. Things that are within the legislative control to change. So the fact that Austin hasn't done it...
Chapter 21 if they wanted to.
Right, so the fact that Austin hasn't done it, this body would supersede itself as a legislative body, essentially, when and if it were to be voted as a commission instead of our good representatives in Austin. to set those types of standards, conditions, policies, laws.
They have more flexibility, and they're exempt from the education code from applying certain things. So they have the flexibility.
So this 15, or so this whatever governing body, if hypothetically this thing goes through and there's a plan, whatever that plan suggests by way of that governance structure, which could be, as Trustee Ranger said, a structure that has nothing to do with elected representation or nothing to do with a group of people being brought forward from the voting population. Those folks basically can become legislators in the sense that they can change the law or write the law as they see fit in a lot of areas because they wouldn't be bound by certain elements of our existing law.
No, they're still bound by federal and state law. It's just certain portions of the education code they're not bound by.
Right. So in those areas, they basically can do what they want. And governance is one of them, essentially.
As long as the people of the district voted up.
So we're called an independent school district in the state of Texas for a reason. And that's because we're a taxing body. Is that not right? And as a taxing body, there's an element to democracy that says you should have taxation with representation. Is that a fair statement?
As American as it can be.
God bless the USA. But in the state of Texas, I mean, we talk about representation as an important part of our democratic process. So explain to me, since this is a taxing jurisdiction, and it's comprised of a number of municipalities and other bodies inside of this thing called a school district, how this home rule entity, whatever this plan creates by way of the governance, has any checks and balances.
And on how they drafted the charter. They could draft a charter that had checks and balances. They could draft one that doesn't have checks and balances.
And then who's checking that? Where's the check and balance in that?
I think can't the voters ultimately...
There are provisions for amendment. There are provisions for repeal of the charter, which are basically the same as the creation. It would be the same type of hoops you'd have to jump through.
So as far as the school finance part of the story is concerned, how does that come into play here? Do they set a would this entity have the power to set a tax rate?
Yes.
So this entity would have the power to tax, but there would be no way to have representation tied to that taxation by the voters who pay those taxes?
Get a provision on a ballot to repeal the charter.
But
Charter amendments on that.
that's way down the road. I'm talking about, you know, this entity where its powers, or this commission could write a charter that essentially says, you know, we can appoint a bunch of folks, or a bunch of folks get appointed by somebody to be determined, because we don't know that, right? For which there's no elections, there's no public input, essentially. And that body could then set the tax rate and make all sorts of decisions about money with respect to spending and so forth. I mean, I'm just trying to understand ultimately where the checks and balances are here.
To a certain extent, I mean, they can't change the obligations that the district has currently. So the taxes and the bond obligations would remain the same, but certainly down the road.
So the liabilities would flow through to the created entity, whatever this entity would be. But the assets would too, essentially. So they take our entire balance sheet with them, but there's no, but they could create an entity that there was no voter participation whatsoever, even though that voter is the taxpayer, or prospectively the taxpayer, or has an interest.
Yeah.
Isn't that a pretty slippery slope? Isn't that why a lot of these folks have not said this is the idea that it's cracked up to be? Because it opens that door and it creates a very different dynamic, as well as a very different legal and democratic structure. I mean, it would be good to understand. I mean, the state of Texas, I mean, with respect to the school finance situation, clearly there's a lot more to this story that we need to understand. And that's another area I would like to see some degree of research and background on what that could mean. Thank you.
flipping pages and reading. Can we go back to section 12.017?
Pre-clearance.
So, but that last sentence, if the Secretary of State determines that a proposed charter contains a change in the governance of the school district, the Secretary of State shall not later than the second working day after the date the Secretary of State makes that determination notify the Board of Trustees of the school district. The last sentence, I want to make sure I understand. The board shall submit the proposed change to the United States Department of Justice or the United States District Court for the District of Columbia for pre-clearance under the Voting Rights Act.
That change.
See, that's no longer applicable because of the Supreme Court ruling in 2013.
Changed it.
So essentially that should not even be something that's a policy change.
We're still in law.
Yeah.
Statute.
Still here.
The statute was not amended subsequent to the Supreme Court ruling.
This was done in 1995 with
And excuse me, when was the ruling? And what was that again? Shelby versus?
Shelby County versus Holder, 2013.
Recently.
Voters' rights.
Trustee Murat.
Can we request the Attorney General to opine on what that means, and perhaps the Secretary of State?
Section 12.017.
The last sentence that the Board President just referred to.
Whether that's a requirement.
It strikes me that it's still in
Commissioner,
state
too.
law, so it strikes me that we should follow state law. That may mean that we don't have to wait for the DOJ to respond, but it strikes me that we still have to send that. That's the reason I'm kind of interested in an AG's opinion and the Secretary of State's opinion on what our proper protocol is, given what's written into the Texas Education.
Isn't that the voting rights happen at the federal level?
Federal.
So federal always, sometimes, depending on the state,
You could
preempt
ask the Commissioner
state.
to ask the Attorney.
So you don't recommend that we ask for that opinion now?
Well, there's only certain entities and officials that by law can ask
so
for
we're not
it.
one of those. Okay, I got you.
You could write to the Commissioner and ask him, or
You have to go through yours. Who do you have to go through to talk to the office?
Maybe a senator, I think.
Your senator. I had a question. See, Cal.
Trustee, are you done?
One other question. So the superintendent read, sort of brainstormed some of the things that you had that you didn't think applied anymore. Can you talk about how that might affect student outcomes?
Yeah, I think, I'm for giving districts more flexibility always. Our focus is on our kids. I know, at the state level there's always good rules and there's always good reasons for the legislation that it passed, but sometimes what we could do here, for example, we need more time. Our kids need more time than kids who are already at the proficiency level. So, for example, we have a lot of kids who are not proficient. We need more time on task, more school days. We're always in favor of supporting our teachers and paying them well. But if our kids are going to have a longer school year, then our teachers are going to need a longer school year, and it can't just be voluntary. We're going to have to dictate that and then pay for it. But those are good. Those will be good outcomes for kids. Again, I'm just answering your question. What could some of those things do for us? And it would help raise student achievement.
Thank you. That's all I had, Mr. President.
Trustee Cal, I had a question. So if I understand correctly, I'm just kind of reading the letter and listening to what you're saying, Superintendent Miles. It sounds like, I'm trying to figure out why we're here talking about home rule charter when we have a law that was passed that you're going to get us the difference between the law that gives us the board flexibility for charter. So is this to just kind of make the board, because it says the list goes on and on, will only grow, shall the board also pass a new teacher evaluation and compensation system later this year? That's one of the things at home rule charter, because the more you talk, the more it seems that you're in support of us going this route, because you keep saying what it will give you flexibility to do when some of that flexibility is at the state level, you are the superintendent, and I look at some of the things that we approved as a board. Everything has gone through to be able to help student with outcome. So I'm just still at that point of kind of confused on what our end goal. Once again, can we get clarification, President Cowan, of the end goal here, and why we are going this? Can we talk? Can they talk to us about the end goal, the outcomes, and what they expect? Because also roles and I requested roles and responsibilities of a trustee. They say we ask that you begin the process immediately by holding a public meeting where you and the community are briefed in public on the home rule law. We're delighted to join you at the meeting if you think helpful. So are we to hold the public meeting? I mean, it's a 501c4. Are they to hold a public meeting? Because in this letter, they say we ask that you, and then it talks about the accomplishment of the board, but goes into the state mandated regulation that the board has no control over. So once again, in looking at the letter, can we get clarification of our end goal, our roles and responsibilities, and where the line, the gray area that Jack talks about?
Again, as I stated earlier, Trustee Nuttall, is that the board can invite these individuals to come to a board meeting and discuss what their intent and what their ultimate goal is, so that board would be fully informed and decide whatever strategy the board wants in regards to that.
But isn't that too late? Because the petition, it says the petition is going out on Tuesday, and so they want to work with us, but yet the petition is going out on Tuesday. And this was formed as we finding out the information in November, and it says they want to work with us. So I'm just trying to understand, once again, why we're here, and we've yet to discuss the budget or what our responsibility in figuring out. It's just sidetrack on. We still have an upcoming budget to approve in June, and a whole lot of other stuff to do that we are sidetracked.
I wrap that up with a legal question about the law itself. So we have a choice. We can either take a vote and start this ourselves, or this group can go out and get petitions. Is that correct?
Yes, sir.
Okay. We're not supposed to take a vote to start it ourselves tonight.
Sir.
I have no plans to put that on the agenda as board president. So next step is it's their move, correct?
Can I ask a hypothetical question?
I think we need to have a meeting with them.
Can I ask, because there's a lot of unknowns here. I mean, this has never been done before. There's no defined process. There's no procedural book on how this should be done in any form except for what's here in subchapter D. So let's say, just hypothetically, 2 501c4s get out there and have petitions, and each goes on the ballot, and one passes, the other doesn't. But they have different motives. They have different intents. You know, how do you define then the focus of the ultimate home rule school district charter? I mean, what should be its charge if you don't know what its end game is? Because technically you can do anything. I mean, you can create you can focus on a very limited areas in a home school charter plan. You can focus on a whole cascade of areas. You could decide to leave the current governance intact, but simply redesign your programmatic areas, for example. I mean, these are all options. There's a myriad of options. So this is the part that's confusing to me. Is I thought, and I was under the impression, that it was the board who set the charge. That is, the areas of focus. For example, we're going to look at governance. We're going to look at, you know, the school day issues. We're going to look at the structure of, you know, teaching and learning, something. I mean, there's at least some guidance about the areas by which, if you go into this home rule school district charter, you know, new entity, you define the areas where you are trying to redevelop, redesign, change the ISD structure. So help me understand that. I mean, there could be 5 different groups out there running petitions, and they could all be different. They all say, let's trigger this commission. But the question I have is, what is the commission's charge? I mean, then it goes back to, we appoint 15 people, and then what? I mean, what's their guidance in terms of what it is, the work that they're supposed to be doing as a commission? I served on the redistricting commission, and we had a pretty specific charge. And I think everybody would tell you all redistricting commissions are the same in the sense that they have a very definitive charge and very definitive rules and laws and guidelines to follow. But in this case, it feels like it's a wide open field. And so we're in the, when we appoint 15 people, what are they doing, essentially?
To get together and create a charter, and then that charter, once approved by that commission, goes to the voters. They don't have a charge from the board members. I guess the board members could appoint.
So the
board
501c4,
members
just because the
to the
501c4 got
commission.
5% of the voters to sign a petition, they basically leave they leave at that point the relationship to the process. They hand over, they're just there to basically run a campaign. But then, once that campaign is ended, and you've got the 5%, you've got the 25,000 signatures that are presented to this board, and they've been verified as being, our registered voters. Then what? Then we just appoint 15 people and say, "Have a nice day." I mean,
Ma'am, you can make suggestions, as been earlier.
Don't have to take them. They don't have to take them.
so it's
They probably
basically the wild, wild west in terms of the power and structure and what they intend to do. And then the question is, what are their motives? I mean, what?
I was going to say, you could appoint some of the board members to the commission if you wanted to, in some of the slots.
Oh, you could put.
Or you could obviously make recommendations, but if you had actual board members on there, that may be an opportunity to alleviate some concerns. I mean, I understand your concerns.
We each can appoint ourselves to the commission.
Well, you
And you get more of
as
it.
long as you
Oh,
make
that's
the-
a good. Oh, that makes it really interesting. We at least can. We is that it? But I think this is the first time.
No, because the individuals who comprise of that board must have children.
Well, 8 of them must have.
School age, yes.
I do.
Well, I know only 2 of you, so I understand that.
I mean, do grandparents account? Just must be children of school age.
And the
in
entire
district.
board has to appoint.
You can point your
We all have
husband,
children in the
your
district.
cousin.
We all have 159,000 children that
Talking
we
about
as
your
a board of
child.
trustees are responsible for.
They're talking
They're
about your
all our
child.
children.
So that'd be
Trustee
me. and
Solis.
I have a couple
can
more
apply.
questions about the minutia, and I was wondering if I wanted to ask these questions, could I direct them? Do I direct them to you, or do I direct them to the lawyers moving forward, rather than sit here and continue to ask more questions that I think can be answered?
I'm not a lawyer, so direct your questions to legal.
If the questions are in the public interest, it would be a good idea to have them in
Well,
the
then
open session.
let me ask one question. The 25% of the commission must be classroom teachers selected by the representative of the professional staff pursuant to section 11.215E. What is representative of the professional staff?
It's the district advisory council, and the district, it has professional staff on it, teachers that are elected to serve on it, and principals.
That's it. Thank you.
Wrapping up, anybody else?
But, just to clarify, the checks on the commission are, first, that the board appoints the commission, second, that the TEA commissioner has to approve the charter, and third, that the voters have to approve the charter.
Correct.
Right, okay, thank you.
The charter, let's be clear, is a plan that this body writes as far as the end-to-end elements of what the school district, the newly constituted school district becomes. Its governance structure, it's the way in which it operates, the way in which it spends funds within certain limits of the existing.
Yeah, there's no doubt about it that they have broad authority to write a charter, but I'm just saying the checks that they go through are, we appoint the commission members, the TEA commissioner has to approve the plan, and the voters have to approve the plan. Doesn't mean that they don't have broad authority, it just means that the authority has some checks on it.
And just so we're clear, the voters issue, the plan that ultimately goes to the voters that's passed through by this commission, it's 25% of the voters, registered voters, have to turn out, and then it needs to be a majority, so at least 50% plus one, whatever, vote is the way in which it passes.
Trustee Mora. Then Trustee Ranger.
Yeah.
So a technical question about the conduct of the commission, assuming it is appointed by the board. That commission is going to conduct public meetings, I'm assuming, in this building. They're going to be posted 72 hours notice. Are they going to have access to y'all as legal services? Do we give them a budget? Do we give them access to district resources? Can you kind of describe what that might look like?
Yeah, who pays for it? Who pays for the commission?
You appoint the commission, they draft the charter. I don't think there's any requirement to pay them anything.
No.
Not pay them. They need an operating budget in which to do their work, do they not?
I mean, I'm assuming they're going to have a bunch of legal questions, so they're going to have some access to attorneys. Do we just, since y'all, for example, are part of our $5 million procurement for attorneys, you just answer their questions just like you would us?
We need to check up on that.
Yeah.
I'm not
Would
sure.
the 501c4
I'm not sure we can
pay
do
it?
that.
Will the 501c4 pay it? Is that what the,
That's a
That would
good
be a
question.
conflict.
That's a real good
I
question.
mean, but that's a question we need to ask. Who pays for the commission?
Yeah, and is there, the other thing I would be looking to is what is the body of ethics rules that would apply to all of the parties in this case?
They're governmental bodies, so the same rules that apply to you all would apply to them.
Well, public officials, there's differing rules. So the question is, where do they fall?
Conflicts of interest, all of that, because we have to submit all of that. And we have to E-rate. How does this impact E-rate if someone's appointed? And
Do you think maybe we can get an opinion on basically that body of questions? The resources, the requirements for this governing body, if approved.
smoking screen.
Mr. Ranger?
Well, I'm just
Seems to me that we are asking for a number of opinions, and we're about to spend a lot of money on something that we have just received a letter about and that we're getting information about. The group has said in the letter, or someone mentioned, and I believe at one point they said they'd be delighted to meet with us or to work with us. But this is after the horse has been let out of the door. They are ready to go tomorrow to do whatever it is they're going to do. And except for two trustees who have met about this, and the paper said, if that's not true, one trustee who helped to start this whole thing. And if that is not true, then that Trustee Morath, can correct us on that. Trustees were not involved in this at all. It seems to me that, and someone asked about the end of this, what's the end result? Well, it's very clear that the end result is to create an alternative system of education, alternative to what we have here. One that potentially could have no checks, no balances. One that potentially does not represent the public. And one that potentially would go towards privatization and corporatization, corporizing this whole school district. And I am totally against that. This potentially puts public education in the hands of a few. We've talked about the money. It appears that there's a lot of money behind this whole effort. And then we said, well, this can be repealed, or if the voters don't like it, but where are they going to get the money? The organizational structure. If people have been working on this all this time, and they have billionaires and millionaires and trustees working with this, where's the public going to get this, to change this, to turn this around? If people wanted to work with us, to talk with us about this, it would have happened long before Friday night when we got a letter at after 9 or 10 o'clock. I appreciate our becoming familiar with all of this, but beyond this, this group appears to be going on with whatever they want to do. They're already, tomorrow I guess is the day they're going to start on what they want to do. My real question is, what is the benefit of this and what they're doing? If they say, and they've pointed out several points about what's going on in the district and what is happening in our schools that we already all know about. But as I think, and I was reflecting on various activities that have happened that relate to public education in Texas, where were these people when we were going to Austin to say, save our schools? Where were these people when we were going to Austin and throughout the state saying, let's make education a priority? The concern for our students shouldn't just start today with creating an alternative system. It ought to be, and we don't need the alternative system. In my opinion, what we need is people with courage. Courage to face the lawmakers. These 100,000 voters you're going to get to sign this petition, take those 100,000 voters to Austin next year during the legislature and let them speak to the legislators and say, this is what's going on, this is what we as voters want to see in public education. What we need is people with courage to confront the laws and the mandates that are preventing us from doing what we need to do in our schools. What we need is advocates to confront lawmakers. What we need is transparency from those who are planning these activities clandestinely and then just before the 9th hour say, oh, here's what we want to do and we want to work with you all. But we're going to move ahead anyway. What we need is an honest conversation with all groups that includes all levels of people who have an interest, a concern, and a support for public education and the children in this district. What we need is a group that says we're going to be honest about what's going on in public education and how we can help Dallas ISD to be better. What we need is truth, and most of all, what we need is integrity, not a group that is trying to form an alternative system that comes to us and they have all the resources to do what they want to do. So beyond today and what we're doing now, what is there for us to do? We're talking about legal opinions. All of those cost money to do this, to do that. If they bring all those petitions, it says that we're forced to do it, and then we move on. But that will be after the time they do that. I am completely against anything, and I want this to be very clear, that opposes public education and Dallas ISD in public education and our making, improving, doing what we're supposed to do as a governing body to make this system and this entity, Dallas ISD, better, because this isn't happening anywhere else in Texas.
Mitchke.
I just wanted to understand again what the board's role is at this point in time. That the board, if it wanted to, as I understand what you said, could create a charter commission. If the board doesn't want to do that, we can be forced to create one if there are 25,000 or so signatures that are presented to us.
Yes, sir.
And there's no other action that we can take if we disagree with the idea of forming a charter commission.
Yes, sir.
Okay.
So just so I'm clear, this subchapter B is now nearly 20 years old, and it was put in place long before all these other options that have come into, all these other tools, all these other things that school districts now have the flexibility to do, whether it's SB2, HB5, all these wonderful provisions. It came into place long before all of that happened. So it's really an old piece of law that's on the books.
I think the open enrollment charter was at the same time, was it not?
Open enrollment.
Most
And
of the
campus
charter
charters.
schools are, yeah.
What it was really trying to do was say local control is important, which I think we would all agree is an important topic unto itself, that districts have the maximum in flexibility and that there be the widest array of options available for our children and in the education system. But what I've heard today is a commission can be formed that has there's no real oversight to its charge. It could essentially abolish education, public education, and maybe even go to a voucher system or some other system that it determines is still within the context of, the rules, and there's nothing to stop it except the voters or potentially the TEA commissioner.
Well, it does have to, describe the educational program. It has to provide that the continuation is contingent on acceptable student performance and compliance with other applicable accountability provisions. But
It doesn't have to answer to the public.
Right.
So you're basically saying if we talk about public education, we can take the public part and throw that in up for grabs, or just make that a.
other than the petition
And it's
process.
also prospectively could be a plan that includes taxation without representation. That's possible. That opens that door.
Anybody else?
Thank you.
We
Mr.
ready to proceed? Yes, ma'am.
Related to this, it is important for us as trustees to discuss our ethical responsibility according to the oath we took to preserve and protect this district. And I'm asking you, President, to put that on the agenda for us to discuss in light of information that has come out that shows trustee involvement, one specifically Trustee Murat's involvement, so that we can be very clear on that.
I think you have a lot of questions that you've been asked to respond, but one of the most important is the makeup of the commission. I think we definitely need opinions and clear guidelines if this does happen. We're going to need very clear guidelines, legal guidelines on who can serve on that commission. Okay? All right.
Were they clear on that? They said who can serve on it. 15.
There's some, what does geographic diversity mean? What does racial, ethnic, socioeconomic diversity mean? What does that mean to us as a body?
But are we going forward with it?
No, I'm saying if this happens.
That we get it at that time, if it happens,
Right.
that we get the information
Correct.
at that time, not paying for it now.
Right.
Yeah.
And also under.
Wait and see mode.
Yeah.
C mode, yes, sir. Okay.
Obviously, like I said, they have us supposed to meet with them.
Okay. It is 8:30 and we're adjourned.